Hello, landlords. So we're talking about complications, and this is one that frightens every landlord when you mention the second appeal. These are rare. They don't happen often, but they can happen for residential evictions. A commercial eviction. Okay, so here's the thing. It can happen in a commercial eviction, but it's totally improper. The Court of Appeals won't hear a case for a commercial tenant on a second appeal, but they will hear an appeal for a residential tenant all the way up to the Supreme Court. And so, can the second appeal happen? Yes. Do they happen often? No. Can they be prevented? Yes. But how do you do that? What are they? How do you do that? How do you prevent them? What do you do? So you are on appeal, and the tenant is just fighting you tooth and nail. The tenant is convinced that they've got a good case. And you go to trial and they lose, you win, they've lost the case, and they say, well, I am going to appeal again. The law says they can. If they can cite error on the part of the court, in other words, the judge got it wrong, if they can prove that, if they can convince the Court of Appeals, they can either get a new trial or the Court of Appeals can change the verdict. But what does something like that look like? Well, a second appeal goes on for a long, long time. It could go on for anywhere as little as 9 months to a couple of years. Yeah, they're that open-ended. They're hard to predict. They can go on for a while, and they are not cheap. They can be much more expensive than your eviction trial because they're much more involved. But again, they're also very rare. And so you're like, I don't like the sound of that. Some of you have already, clicked. You're watching some other video now. So for those of you who are still here, there is some good news. One of the steps in preventing the second appeal is the supersedious bond. If in your judgment on the first appeal in the county court sets a proper supersedious bond, you can actually prevent 99% of the second appeals, because typically the courts will allow a supersedious bond in the amount of 10 times the monthly rent. So if it's a $1,000 a month rental fee, you're looking at a $10,000 cash bond. Well, why is that important? Well, because in order for them to prevent the writ of possession after this trial, the second trial, so you're here in the county court level. In order for them to prevent the writ of possession from issuing, they have to pay that bond within 10 days of the judgment. Most of them don't know that rule, and they don't understand that rule. So even if they're convinced that they're going to appeal, they don't, right? Number one, they're not going to come up with it. They can't come up with your rent. They're not going to come up with $10,000 for a cash bond. And so they'll either sit on their hands, and even if they can come up with it, they probably won't come up with it within 10 days. And because of that, 99% of these just die. They're dead on arrival. And so if you set a proper supersedious bond at the county court level, 99% of these are prevented. However, if you are that unfortunate, landlord who gets a tenant who does pay the supersedious bond, or if somehow you didn't set a proper supersedious bond and they file a second appeal, you could be stuck in front of the Court of Appeals without an ability to get a writ of possession for quite a long time. That's going to require some very specialized help, something that we could handle for you, but it's much more complicated at that point, And so the strategy changes tremendously. If you can prevent it, you're much better off. All right, happy leasing. Bye.